The final case this morning is Sanders versus Tumbleweed Saloon and Sean Spahn.
Good morning, Your Honor. Scott Feuer on behalf of the defendant, Tumbleweed Saloon. The issue before the court today is whether the plaintiff's first attorney entered into an attorney-client relationship with the plaintiff. And as the court can see, I brought a blow-up to discuss the different options that the legislature had when enacting this statute. And what I want to focus my argument on this morning is what we believe is the unambiguous language of the Dram Shop Act, MCL 436.1801. The statute was amended in 1986, and one of the problems with dram shop cases at that time when the tort reform legislation was being passed was that savvy plaintiff's attorneys would do an investigation of a case, would line up their witnesses, and then they would wait until the eve that the statute of limitations would expire before filing suit. So 2 years down the road, the restaurant or bar that was being sued would get a lawsuit. And I can tell you, having done this work for 34 years, going back to 2 years to a night in a restaurant or bar and trying to find out who was there, who saw what, who remembered what. In other words, trying to find witnesses 2 years later was difficult. So when the legislature decided to pass the amendments to the Dram Shop Act, one of the considerations was, well, let's shorten the statute of limitations because this is not being fair to the restaurants or bars. They have no way of defending this because the plaintiffs have a 2-year head start in obtaining witnesses and evidence. So there's probably more possibilities that the legislature could have entertained, and let me just read those for the court. The first option was the legislature could have made mandatory that the plaintiff provide notice within 120 days after the incident. The second option, which was what the legislature chose, was that the plaintiff's attorney had to provide notice within 120 days after entering an attorney-client relationship. The third option that the legislature could have chosen was that the plaintiff provide notice within 120 days after retaining an attorney. Now, the first option would have been very onerous for the plaintiff. The plaintiff may have been hospitalized. The plaintiff might not see an attorney right away. The plaintiff is not knowledgeable about the law, and the plaintiff may not provide such notice. The court may know that in certain other types of cases, such as governmental immunity, in fact, the legislature chose that option. But that obviously was rejected because we've seen the plain language of the statute. The third option that the legislature had was to make mandatory that the plaintiff's attorney provide notice within 120 days after retaining an attorney. Now, that option similarly was rejected, and it was rejected because a plaintiff's attorney could simply state that I was investigating a case and I wasn't retained until just before I filed the lawsuit on the eve of the statute of limitations.
Counsel,
So
I'm over here. Sorry. Is your position is that number
Did
two
you
is?
speak up behind him?
I know. I have noticed that somehow it bounces off.
Yeah, there's an echo in here.
I know. Your contention is that what you have up there as number 2 is the language that the legislature chose. Except it's not quite complete, right? It says 120 days after entering into an attorney-client relationship for the purpose of pursuing a Dram Shop Act.
That's correct, Your Honor.
So you could enter into an attorney-client relationship for purposes of investigating whether you have a claim, correct? But I mean, the relationship that is triggering the notice requirement is a relationship for the purposes of pursuing a Dram Shop Act.
That's true, Your Honor. My poster board was only so big I couldn't
Okay.
include the
I just
entire language.
wanna-
But I think what you're asking is, and what's important, is this court's decision in Landgrove versus Stingers. And in that case, this court held that there's a presumption that when an attorney-client relationship is entered into, that it is for purposes of pursuing a dram shop case. So I don't think that hasn't been an issue in this case. I don't think it's an issue in this case pursuant to this court's decision in Landgraf.
Okay, so I have a question. So this is sort of an odd, by my read of it, it's an odd notice provision, because I think most notice provisions, it would make more sense to go with number one, right? You have a single concrete event that happens, the date of the incident, and your notice period is then going to run from that. Or even perhaps the date of filing suit. You can back out how many days in advance of suit notice must be filed or something like that. Here, the notice requirement is tied to an event that can occur multiple times, correct? They could enter into an attorney-client relationship, even for purposes of pursuing a Dram Shop Act, 17 times before they file suit. So why is it, because the Act doesn't say the first time you enter into an attorney-client relationship, it says 120 days after. So in this case, even if we were to find that they had entered into an attorney-client relationship with attorney number one, and the notice was insufficient to satisfy the statute, why does that matter when they've actually complied with the statute through attorney two?
Because the language says an attorney-client relationship. And if the court was to adopt Justice Kavanaugh's argument, it would defeat the whole purpose.
Well, but typically, it doesn't say after entering into the attorney-client relationship, which would suggest only one. An attorney-client relationship means that there could be more than one. It actually, and it doesn't say the first attorney-client relationship. It says an attorney-client relationship, which suggests that this event, I mean, I will admit, it's odd to tie it to an event like that, because that could occur multiple times. But so even if they failed in the first instance, why does the fact that they complied in the second instance, why doesn't that satisfy their notice requirement?
Because that would defeat the whole purpose of the statute. This was a compromise, as you can see, by the legislature when enacting the statute. What they wanted to do was they wanted to avoid a plaintiff, and a plaintiff could, as you point out, jump from attorney to attorney and get the 120-day clock ticking fresh, anew. But that would defeat the whole purpose, because a plaintiff could do that, go to a new attorney, start the clock ticking again, and meanwhile, you're doing exactly what the legislature wanted to avoid, and that is putting the defendant on notice so that the defendant could be on equal footing with the plaintiff in attempting to investigate the case and trying to line up witnesses or evidence.
But how would it conflict with the plain language of the statute? I'll take your word for it that the legislature was searching for something that was more fair for the reasons that you explained. That makes sense to me. But given that what it says is 120 days after entering into an attorney-client relationship for the purposes of pursuing this act, and we know the plaintiffs did that with their second attorney, and they met the notice with that second attorney, how do we read that plain language as problematic, given that?
Well,
I mean, we take your word for it about the background, but what we're left with is 120 days after entering into an attorney-client relationship, which they met that deadline after the second attorney.
One thing the court should look at Landgraf and the prior cases that have interpreted. The courts, both this court and the Court of Appeals, have always interpreted the statute to start the 120-day clock from ticking from the first attorney that was seen by the plaintiff. And the court has to recognize, by the plain reading of the statute, what the legislature was trying to accomplish when enacting the statute. Now, if the legislature could have chosen to take the third option, to say we're going to do it 120 days after retaining an attorney. But the legislature recognized that could be problematic because there might be games playing with plaintiff's attorneys, that a plaintiff's attorney may not have a formal retainer agreement until much later on, closer to the expiration of the statute of limitation.
What
With the
about the-
interpretation you're espousing, the same thing would happen. A savvy plaintiff could avoid the application of the 120-day rule by simply hiring another attorney. The whole intent of the legislation was to provide this early notice.
What about an unsavvy plaintiff, like maybe the opposite of a savvy plaintiff, who, goes to the first lawyer they know of, the lawyer who handled their, parents' divorce, and that they have a meeting, and that lawyer's like, oh, that sounds like you might have a dram shop claim, but I don't know anything about dram shop law, so, try another lawyer, and they call another lawyer, and that lawyer's like, oh, that sounds like you might have a dram shop claim, but I'm a tax lawyer, and it just takes them a while to find the right lawyer that they are going to enter into an attorney-client relationship for the purposes of pursuing a dram shop claim. I mean, they may well have had a number of interactions with attorneys before then, but it's not until they find the one that's actually going to pursue their dram shop claim that their 120 days starts ticking. Is that right?
No, I would disagree with that, Your Honor. I think it
Okay.
starts with the first attorney, and there has to be, and that's why the legislature...
Even if the first attorney says, I don't know anything about dram shop, I'm really not your guy. I'm really going to screw this up.
I think
Like,
so,
you don't
Your
want
Honor.
me. Yeah.
Yeah, I understand that in practicality that may happen, but the legislature had to come up with a provision that, and that's why they rejected the first option. That's why, because it would be unfair to a plaintiff. But once the legislature was saying after a plaintiff sees an attorney, regardless of that attorney's level of expertise, regardless of what the purpose of that was, the legislature chose the word relationship, which is a very general term. The term relationship is very different than retention.
Is there an attorney-client relationship when the attorney declines the representation?
I think there is, Your Honor. If the attorney is performing any act on the part of the client, in pursuit,
I mean, the
if
legislature could have said 120 days after you consult with an attorney, right? I mean, there's a difference between consulting with an attorney and entering into an attorney-client relationship, right?
I'm not so sure about that, Justice Viviano, because by using the term relationship instead of retention,
I mean, the lawyer has some duties to the prospective client, right? But they're different than the duties or fewer than the duties you have to an actual client, right?
that's true, Your Honor, but I think that's why the operative term is relationship. I'm not so sure there's a difference between consultation and relationship. And sure, if a potential client calls an attorney and says, can you represent me? And he says, no, maybe that's not entering into a relationship. But the legislature specifically chose a very general term,
I mean, so if you
relationship.
go to the office and you meet for 15 minutes and you say, what's your case about? Oh, that? Okay, I don't handle that. That's an attorney-client relationship?
I mean, we can come up with all kinds of hypotheticals as to the spectrum as to what a relationship is. But
I mean, it's
respectfully, I
important.
don't think we're faced with that in this case when we look at the undisputed facts of this case. That's not the case we have here, and that's not in front of the court. What we have here, the undisputed facts are, let's go through them. The question that this court has to decide is whether these undisputed facts show an attorney-client relationship.
Yeah, where to draw the line. That's the whole point of the case, isn't it?
I'm sorry, Your-
Where to draw the line. Isn't that the whole point of the case?
Exactly,
Figure
Your
out
Honor.
where to draw the line.
And the question here is, and we believe that reasonable minds cannot differ, given the facts of
I
this case.
understand your position. I need to know why, the reasons that support it. So
Because
you're agreeing that if they called Mr. Meckler on the phone from wherever up north this place is located and said, I have a dram shack case, will you represent me? If he said no on the phone, you're saying that's not an attorney-client relationship, right?
that's probably accurate.
So they drive down from wherever they are to Southfield or wherever his office is, and they meet in his office for 15 minutes, and they say, this is what happened. He says, I can't help you. Is that an attorney-client relationship?
I'm not sure, Your Honor.
Why not?
I do know,
So it matters whether it's in the phone for 15 minutes or whether they meet in person, that makes the difference?
I think the court has to look at the circumstances involved in the case and determine whether reasonable minds could differ, but that a relationship occurred. Though you're astutely pointing out cases where it's more of a gray area. And I
Well,
don't know if
we're not
the
just
court can
worried
set a
about-
black letter rule as to what in every factual circumstance what might constitute
But that's our
an
job,
attorney-client
that's our job
relationship.
description, you just named it. We have to make the black letter law, legal rule that'll apply to thousands of cases henceforth and hereafter. So we could talk about your case, which we are, but we also have to think about a rule and how it would impact other cases. That's why, that's what my questions are designed to
Understood.
elicit from you. And so I'm trying to figure out, is it the fact that I think the lawyer wrote this letter, this preservation letter? Is that what makes this different? Or, I mean, so that's what I'm trying to figure out, what it is, at what point did this cross the line? And for what reason did it cross the line, in your view?
In my view, when an attorney takes any affirmative action on
What
behalf of the
if
client,
they're not authorized by the client to do that?
I think that under the case law, I think that's no different than an attorney who agrees to a settlement without authority from his client.
Isn't it
That's between the
implicit-
attorney and the client.
Counsel, isn't it implicit in your arguments that this letter from Meckler would not likely have been sent purely on his own accord, but that there'd been some discussions that almost certainly took place in advance of that letter being approved and sent?
Of course, Your Honor. I mean, it's similar
Why are you
to,
not arguing that then?
I did, Your Honor.
Okay, it was
Yeah, no, but
lost,
I
it
do-
was lost on me, but
Okay, and that seems to follow up on Judge Viviano's questions as well, that when an attorney states unambiguously that he's representing a client, to me, that's an easy case. Unlike some of the hypotheticals posed by Justice Viviano, and you're correct, Your Honor, when we have a letter like this from Attorney Meckler, who states that he's representing the plaintiff, that certainly constitutes an
Well,
attorney-client
I may be
relationship.
correct on that, but I'm also correct on the fact that you've got three players here, each of whom denies that there was a legal relationship entered into. The letter certainly communicates the perspective of one of those three individuals, but it is indeed his own perspective. What are we to make of the fact that all three critical players here deny that there was a legal relationship?
I think you look at the language of the statute, and that states that if there is an attorney-client relationship, and the court has to look at what's
Well, the
reasonable.
question in this case is whether there's a genuine issue of material fact. Is it not?
It is.
Okay. Am I being unreasonable in suggesting that generally, maybe not invariably, but generally there is a genuine question of material fact when you have all three basic players in agreement that there was no legal relationship entered into, and that's the question before the court?
No, Your Honor, not when you look at the undisputed facts. When the court looks at the fact that, and this is not in dispute, that Mr. Meckler's a personal injury specialist, that they drove from their home in northern Michigan to Mr. Meckler's office in Southfield, that it wasn't, as the dissenting judge in the Court of Appeals said, this was not for a coffee klatch. This was to discuss the potential case they had.
Well, he had been her attorney previously in an unrelated matter, right? I mean, so he was the attorney she knew, right? I mean, somebody who had successfully helped them navigate a different cause of action. So I mean, I don't think driving to see somebody, if they had looked up in the phone book and said, well, this is the one I think I'm going to go with. I mean, she had a relationship. She knew who this was. Why does that cut any more in favor of there being a relationship as opposed to that it wasn't, that it was just consultation?
Well, regardless of how it came to be that the plaintiff consulted with a certain attorney, whether it was from a phone book or because of a prior relationship or because of a referral, whatever it was, they drove. This was not, they didn't go out to dinner together. They didn't meet at a local coffee shop.
Does it matter really that they drove or how far they drove?
I think these are all indicia of an attorney-client relationship, that you look at it as a
So
whole.
if they went to a lawyer, I don't know what town this is, I should know, but if they went to a lawyer wherever this pub was located, that would be less indicative of an attorney-client relationship? Or
No,
or if they happened to live across the street and they only had to walk, that would be less indicative?
No, I'm
The
not.
lawyer's office?
I'm not suggesting that. I'm looking at what evidence is there on this record that there was a professional relationship between the plaintiffs and her attorney. And I think one of those is that they went to his office as opposed to,
I mean, they didn't
Well,
see him at a cocktail party. I mean,
right.
I think your point is that they did travel some distance in order to speak in person, and then we're trying to decide what it is that they talked about, and the letter tells us some things. They must have discussed that he was injured, because the letter states so. They must have discussed that this injury occurred December 2nd, because the letter states so. The letter goes to highway bars, so they must have discussed that it occurred as a result of consuming alcohol at the highway bar. And they must have discussed that there was a videotaping system, because that's also noted in the letter. Don't all those factors weigh in favor of your conclusion that there is some sort of attorney-client relationship as a result of this meeting?
Absolutely, Your Honor. And that's why there's no, why reasonable minds could not differ, but that there was this professional relationship that was entered into. Regardless of what the plaintiffs may say later on, and regardless of what Mr. Meckler puts in his letter, which of course is diametrically opposed to his affidavit.
What onus is on the client? If you're a client and you're visiting an attorney, what should the client have done differently?
I'm not sure that the client would have done or could have done anything differently. And the remedy, but the client is not without a remedy. Again, it's similar to a client whose case is settled by their attorney without providing the attorney with authority to settle the case. The client, in such a situation, that's may not be an ethical act by the attorney, and the client may have a cause of action against the attorney. But what the courts of this state have held is that an attorney can act on behalf of a client, and the client is bound by the acts of his or her attorney.
And I guess I'm going to go back to Justice Viano's question. I know we're focusing on distances and travel, but how significant is the letter?
Extremely significant. I mean, of all the evidence, that to me is the most significant piece of evidence when you have the attorney affirmatively and unambiguously stating that he's been retained by the client.
can I ask I know you're out of time, but a hypothetical sort of follow-up? Because I was trying to get you to the letter, because I don't think all the other stuff really matters much. The case is about the letter, really. But hypothetically, what if a person gets injured, has a big claim, goes to lawyer A, and meets with lawyer A and thinks, you know what, I really don't like lawyer A. I don't want to hire lawyer A. I'm going to get out of here. And lawyer A now has this information, writes a letter, I represent client on this great claim, please send me, or, preserve the evidence and do this stuff, and lawyer A tries to insert him or herself into the case. Does that trigger the statute?
Absolutely, Your Honor. That shows that there was an attorney-client relationship. Now, if there wasn't, then that's between the plaintiff and his
So
attorney.
you really think at any consultation, you call lawyer A on the telephone, and any consultation where information is conveyed triggers the statute?
No, again, I would say what triggers the statute is some affirmative action by the attorney.
Even if the person says, boy, I really didn't like you, I don't like your personality, I don't like the way you dress, I don't like, the way your secretary addressed me, I don't like anything about this operation. I wouldn't hire you if you were the last lawyer on the planet. That's an attorney-client relationship?
If the attorney investigates the case, sends a letter on the case,
So the
certainly if the
attorney
attorney
goes rogue,
I'm sorry, Your Honor.
goes rogue,
Yes, Your
that's a
Honor.
relationship?
That's between the plaintiff and their attorney. Certainly, when the attorney sends a letter stating that he's representing the plaintiffs, that
So it can
certainly
be
is enough.
unilateral, doesn't have to be a meeting of the minds. in
Correct,
your
Your Honor.
view.
That-
Not much of a relationship at that point, I don't think, is it?
It's a relationship. It might be a bad relationship. but-
Wait, I just want to understand your argument. I'm just trying to understand the argument. So a person goes to visit a lawyer, they don't choose to hire the lawyer takes a unilateral action, then your argument would be that then there is in fact an attorney-client relationship?
Correct, Your Honor.
What if I don't know? What if I'm the client going to Justice Viano's question? I go to visit the lawyer. The lawyer does that. I have no knowledge. I just want to go back to the emphasis of this. And there's no knowledge that the letter was sent. There's still a relationship? I don't know as the prospective client that the lawyer took this action. Do I still have a relationship with that lawyer?
Yes, Your Honor, if your attorney takes affirmative action. And again, it's been recognized by this court and the Court of Appeals in a number of cases. It's no different than if an attorney acts in contravention of his client's wishes. The courts have held that an attorney's statements are binding on his or her client. And that, again, that may not sound equitable or fair to us, but the remedy is
But isn't
between
that
the plaintiff
after
and
the
his attorney.
attorney-client relationship has been established? The attorney can act in that capacity, right? Not before.
But if
If you walk down the street and an attorney walks, on the other side of the street, then if the attorney takes some action, you're bound by that? I mean, there's got to be a forming of a relationship and presenting yourself as having that relationship before other people can rely on it, don't they? Doesn't there have to be some basis for it?
Well, again, yeah, I believe there should be.
In other words,
and
the
it-
action itself it's like a boot and suspenders thing, or, bootstrapping. The action itself can't establish the relationship all on its own, can it?
Yes, again, if there's an affirmative action by the attorney. Now, certainly you pass somebody on the street and say, oh, I got beat up, and the attorney does some affirmative act, that might not seem fair. But the law and the precedent in this state is that then you have a cause of action against your attorney. We take, as officers of the court, if an attorney makes a statement, then the client is bound by that statement.
Thank you, counsel.
Okay, thank you, Your Honor.
Matt Hanley for appellees David and Heather Sanders. I think you've basically touched on most of my argument. I think what we have here is the appellant stating that any act by an attorney is binding regardless. And I think my position is that the client either has to have some sort of mutual assent or reliance upon the attorney for there actually to be a relationship in effect. I think that's actually the current law in Michigan. I think the McComb case states that the rendering of legal advice by an attorney and the client's reliance on that advice is the benchmark of the relationship. And here we have testimony by both plaintiffs that they did not rely on Mr. Meckler to send any letter. So whether, then that comes down to, I guess, a question of fact on who do we believe, since Mr. Meckler at one point stated that he did represent them. Quite frankly, I don't think there's the only other thing that appellant's asking for is that if you do require the bind the client by any attorney's statement, all you're really doing is shifting harm onto that client. And in effect, in certain cases, you may go after, you're able to go after the attorney in that case. If it's an attorney who doesn't know the specific area that he's investigating, and then you may leave the client out to dry. And that's, I think, what we're trying to avoid. And I think there needs to be some sort of reference that the client is relying and understands what exactly is going on in his relationship with a prospective attorney.
You still have free fire time, but can I interrupt you anyway?
I'm done.
Okay, great. Thank you.
Yeah.
I'm a little confused by the Court of Appeals majority saying that there is a question of fact about whether the plaintiff has met the notice requirement. I tend to agree with the dissenting judge that we think of a notice requirement as a prerequisite to suit, or it's sort of jurisdictional. So I understand sometimes there are factual questions that have to be resolved to determine whether a plaintiff has legally met a notice requirement. And so, in this case, there are facts related to that notice requirement. We know what they are. There's the letter, then there's the testimony from your clients, as well as the testimony from Mr. Meckler. And the trial judge considered those facts and found that the letter did more work than the rest of it, and therefore legally the plaintiffs had failed their duty to meet the notice requirement, because according to the trial judge's finding of the facts, the relationship was formed with Meckler. And then the Court of Appeals majority sees the facts differently. They think that the rest of the facts, apart from the letter, do more work, and at least it's questionable when an attorney-client relationship was formed. And so I guess if the Court of Appeals majority had said, we think the trial judge erred in finding that there was that the plaintiffs didn't meet the notice, we believe, in fact, we would resolve the facts differently, and the plaintiffs did meet the notice. That would be one thing. But what they said instead was it's a question of fact, as if you're going to go to a jury and say to the jury, okay, jury, first decide whether the plaintiffs are legally entitled to argue their case to you, and here's the notice question, and you have to resolve the notice question. And then if you decide they can argue their case to you, decide, whether they win their case. And that feels a little bit like we don't do notice like that in any other statute. Maybe there's a reason this one's different, but can you address that?
I mean, yeah, it's somewhat difficult on the notice issue. I mean, you have pretty clear case law stating that when you have an agency relationship, that's always a question of fact. That's kind of more my take on it. And maybe you have to submit that to a jury because the case law for over 100 years has said that that's sort of that's the requirement. That's how I took it. I didn't, you could say the trial judge or the trial court was wrong on its determination.
I think of the trial judge sometimes has to find facts to make a legal determination about what I view as kind of a jurisdictional or prerequisite to suit, right? Mm-hmm. Like if every notice is a question of fact, then there's no benefit to a defendant in the notice at all, right? If it's always basically, if the notice itself goes to a jury in addition to the merits case, that feels like complicated. You know what I mean?
Yeah, and I think I looked at this a little bit in the a governmental immunity a notice in that case. I mean, there's established case law saying that is a question of law.
Right.
I didn't find that in this case. I mean, and that's as far as I could really. There wasn't anything further.
It's just another weird thing about this whole dram shop notice, I have to say.
Mm-hmm.
I mean, I assume you didn't write the statute. Any other questions?
When the Mecklers said, or when the Saunders and Mr. Meckler sat down, was that discussion privileged?
Yeah, I believe so.
Why was it privileged?
It was discussing of a legal issue. I mean, he was this lawyer. He was a prospective client. The rules of professional conduct provide that that's a privilege in that situation.
Does that not, at least for the purposes of that discussion, create an attorney-client relationship?
That's where I disagree. I don't think it does because the Sanders never consented to an agreement or he made took any implied action or acts that would show some sort of agreement or reliance on using Mr. Meckler in any fashion.
Can an attorney owe an ethical obligation to even a potential client to maintain attorney-client privilege? That is broader than even if they don't form an attorney-client relationship with that individual?
Yes, I think that's the rules of professional conduct 1.18 either in.
Those are broader. Those might attach even in the absence of forming an actual attorney-client relationship.
Right. I mean, the way I view it is that whenever I get a telephone call from a prospective client, I'm not going to go out, even if I say no thanks, I'm not going to go out and discuss that with anyone. I think that's pretty standard. I'm not sure why that.
Okay.
Can I ask you the same question I asked your opposing colleague? How plausible is it that Meckler sent the letter requesting the preservation of evidence completely on his own accord without having discussed the matter beforehand with plaintiffs? In other words, although the parties here disagree as to the existence of an attorney-client relationship, how genuine is that disagreement?
The letter was an obvious negligent act, to say the least. I mean, I can't really account for him. How plausible is it that he was investigating the actual case and
How plausible is it that he sent the letter he did, identifying himself first as the representative of the parties, and secondly, asking the recipient of the letter to undertake certain precautionary actions with regard to evidence? How likely is it the letter was sent out without some tacit approval or some communication between Meckler and his clients, in quotation marks?
Well, I think you have my clients both with quite a bit of surprise, and then you have ultimately a question of credibility, which would go back to a question that has to be answered by a jury.
How relevant is it that the letter that Mr. Meckler sent didn't in fact mention the Dram Shop Act or identify any AIPs or anything like that? What relevance is that, or significance is that fact to whether or not there was a relationship formed for purposes of pursuing the Dram Shop Act? I mean, does the omission of those things suggest that this letter was as a favor to preserve, don't destroy your videotapes? I represent them, I understand that, and he was injured in this place on this date. No mention of the Dram Shop Act, which is what's required to satisfy the Dram Shop Act statute, but this letter didn't have that.
Quite frankly, I think the Langrel opinion still would say that that's not, that this would be sufficient to be well, it's an improper notice, but it's still a notice under the act. That was my interpretation. I'm not trying to argue that it wouldn't trigger it and we'd go back.
Would it suggest that there wasn't a relationship for purposes of pursuing an action under the Dram Shop Act because the letter didn't even mention the Dram Shop Act?
I still think from the previous case laws said that still probably would apply under the Dram Shop Act as a notice. So I'm not really disputing that.
Okay.
Okay, I see no further questions. Thank you very much,
Thanks.
counsel. The case will be submitted. It's 11:35. We'll take the bench at 12:15 for our afternoon cases.